Hi, very good morning. This is a interesting Supreme Court judgment under the Negotiable Instruments Act. Supreme Vishnu Mittal versus Shakti Trading Company. That is the citation. Facts are that appellant was a director in a food and beverage company. There was a contract between the company, that is his company. The company has become a corporate debtor, and the respondent. Appellant, in his capacity as director, he has drawn several checks. The checks, when they were sent to the bank, it was all the checks were dishonored. Legal notice was issued by the respondent. Complaint was filed. In the meanwhile, insolvency proceedings against the company, that is the corporate debtor, started. A moratorium order was also issued under Section 14 of IBC. On the very same day, IRP, that is Interim Resolution Professional, was also appointed. In the meantime, since the complaint was filed in the criminal court issued summons to the director. Then director approached the High Court for relief in view of the moratorium order. High Court refused to quash the complaint and give any relief to the director. Some dates are very important, for just 4 dates for this case. One is 25/7/2018. That is the date on which moratorium order was issued. 25/7/2018. All the checks were drawn prior to that date. That is prior to 25/7/2018. Then the notice under section 138 was issued on 6/8/2018. Then the 15 days time for making the payment, for making if the checks are dishonored, then if a notice is issued, they generally at that point in time, the 15 days time is given to make the payment good. Otherwise, then they will go and file the complaint. So that 15 days time expires on 21/8/2018. High Court dismissed the writ petition on the ground that the immunity granted will protect only the corporate debtor and not the natural person like the director. So that was the view of the High Court. So this director went and filed an appeal against that order before the Supreme Court. Supreme Court opined that the return of checks simpliciter will not create an offence under section 138 of Negotiable Instruments Act. The cause of action arises only when the demand notice is issued and payment is not made within the prescribed period. Supreme Court said in the present case, the moratorium order was issued on 25/7/2018. The management of the corporate debtor was taken over by the interim resolution professional on the same day under section 17 of the IBC. In such a case, the appellant director did not have the capacity to pay the amount to the respondent. When the notice was issued, the appellant director was suspended from his position as director of the corporate debtor because of section 17 of IBC. All the powers got vested in the interim resolution professional, and the bank accounts were also operated under the instructions of the interim resolution professional. Hence, it was not possible for the appellant director to repay the amount. Additionally, this was also brought to the notice of Supreme Court that the interim resolution professional made a public announcement inviting claims from the creditors of the corporate debtor and the respondent, the Shakti Trading Company. They also submitted their claim. On the above reasoning, Supreme Court quashed the summons and complaint against the appellant director. This is one of the interesting judgments because once a moratorium order is issued, and if the payment cannot be made after the moratorium order is issued, then the directors of the company are well protected. That is the crux of this judgment. So, thank you very much. Have a great day.